Secretary of Visakhapatnam branch of SCRs of ICA, CA Prashant Kumar Panda, renowned speaker of today's virtual CPE seminar, CA PVSS Prasad Garu from Hyderabad, my colleagues in the committee, senior members of the profession, past chairman, my dear professional colleagues, ladies and gentlemen, a very good evening to you all. CA PVSS Prasad Garu is well-known resource person to many members of our branch. He is a regular speaker on the topic of finance bill for many years, just immediately after the union budget presentation of each year, and also many other conferences and mega conferences conducted by our branch. We, the members of Visakhapatnam, express our sincere thanks to CA Prasad Garu for immediately accepting our request to address us today. About today's topic, the Multilateral Instrument is a multilateral treaty that enables jurisdictions to swiftly modify their bilateral tax treaties to implement measures designed to better address multinational tax avoidance. Multilateral Convention to implement tax treaty related measures to prevent base erosion and profit shifting is the official title of the multilateral treaty framework that aims to prevent BEPS. The multilateral instrument is a treaty which is one element of the OECD BEPS project designed to help implement the recommended measures to avoid tax treaty abuse. Countries will be able to use MLI framework to implement some of the BEPS action plans relating to double tax treaties. Abuse of tax treaties is an important source of BEPS. The MLA helps the fight against BEPS by implementing the tax treaty related measures developed through the BEPS project alongside existing bilateral tax treaties in a synchronized and efficient manner. These measures help combat treaty abuse, improve dispute resolution, prevent the artificial avoidance of permanent establishment status, and neutralize the effects of hybrid mismatch arrangements. MLA is developed by an ad hoc group of 100+ jurisdictions and signed by India along with representatives of 65 countries. As of 22nd September 2020, 94 jurisdictions have committed to participate in the MLA. In addition, 5 countries have expressed their intents to join the MLA. Out of 94 jurisdictions, 52 have ratified the MLA and deposited their instruments of ratification with the OECD. The MLA articles are effective for withholding taxes in 2020 for the 33 jurisdictions. To enlighten about many other issues involved in this multilateral instruments, we have expert speaker CA PVSS Prasad Garu with us today. By the end of this session, many of our doubts will be cleared for sure. Let all of us gain thorough knowledge from his session. Now I request our immediate past chairperson CA Bharati Dev Garu to introduce the speaker CA PVSS Prasad Garu.
Thank you, Chairman sir. I am much privileged to introduce CA PVSS Prasad, who has qualified his law graduate also along with the chartered accountancy and also an information system auditor, and is a partner of Messrs. Prasad and Prasad Chartered Accountants, Hyderabad since 1986. He is the past chairman of Hyderabad branch of the Institute of Chartered Accountants of India. He is the past president of the AP Tax Bar Association and the past chairman of International Fiscal Association, Hyderabad subchapter. He is the past member of the Executive Committee of International Fiscal Association, Indian branch. He also co-authored a book titled International Taxation, a Basic Study, published by Book Corporation, Kolkata. He was appointed as one of the branch reporters for IFA Congress 2010 that was held at Rome, Italy, on the subject Tax Treaties and Tax Avoidance, Application of Anti-Avoidance Provisions. He was chairman of All India Federation of Tax Practitioners, South Zone for the term 2010 to 11. He was also a co-opted member of Committee on International Taxation of the ICI for the year 2016 to 17. He was invited to speak at IFA Asia Africa Conference held in Mauritius in May 2012, May 2014, as well as in May 2016. He is a co-opted member of Committee on International Taxation of the ICI for the year 2018 to 19. He is an elected vice chairman of IFA Indian branch from 2018 to 20. He was invited as a panelist at Asia Pacific Regional Tax Conference 2016 held in Seoul, South Korea in May 2016. With these words, I introduce our today's speaker to our members. Thank you.
Thank you, Madam Bharti Dev garu. Now I request the speaker Prasad garu to take up the session, sir.
So thank you very much, Chairman Mr. Murali Krishna and immediate past Chairman Bharti Devi garu for her kind words of introduction and all that, and other members of the profession who are now participating in this virtual session of Multilateral Instrument. And it's my pleasure to be always associated with Visakhapatnam branch of the Institute. I have a long bonding with this branch, at least from the last 15, 16 years. I've been speaking in your branch whenever there is an opportunity. And I thank Mr. Murali Krishna for inviting me today. And it's my pleasure to share the latest developments on the international tax front. So as I agree, I would not, classify Vizag as a small place or a small center. It's a real growing city in a big way, and the investments are bound to happen in a big way. And we all must gear up ourselves to any sort of, the consultation that is required by your clients in respect of investments coming in or for the investments to be made by the Indian companies outside India. Anyhow, be that as it may, we all have been hearing about the BEPS and the anti-avoidance measures. As you know, the very BEPS means base erosion and profit shifting. And in fact, in 2008, when there was an economic meltdown that has started globally, and large multinationals like Goldman Sachs and Lehman Brothers had a real hit. And then countries like USA and the European countries started looking at their coffers and tax collections. To their surprise, they found that large corporations are managing to pay hardly 1 to 2% of their global revenue as taxes in the countries. And with that, they have initiated a process to introspect and look at the international tax rules that are in existence, whether they are really effective and whether they are really working in tune with the changing business models. And it was found that the international tax rules are century old, and they're very ineffective in dealing with the current business models. As you all know, the technology advancement has taken different leaps, and now we are in a digital age, and more so the digital age, the old rules will not help us in any way, help us in the sense they help the governments in achieving the legitimate tax collections. So this has really prompted them, all the governments, to come together, and OECD took the lead. And OECD, immediately joined by G20 countries. India is part of G20. India is not a member of OECD, but an observer. And then very soon, this became a huge inclusive framework of more than 135 countries. So the whole agenda, in simple terms, this BEPS is not a rocket science. It is an anti-avoidance rules that are being brought in the treaty law to ensure that loopholes are plugged and legitimate tax collections are made at the place where real value creation is happening, at the place where real economic activities are happening. All through multinationals are able to manage in such a way that value creation is happening at one place, whereas the tax collection is happening in a tax haven or a low tax jurisdiction. Thereby, the tax collections are not to the expectation or not to the legitimate level. So all this has prompted OECD G20 BEPS initiative process to look at the rules and rewrite the international tax rules. So they have to bring out the substance over form approach, which we are, I'm sorry, I just put it. I thought of putting this on silent mode, I forgot. So, because I was expecting some call from the organizers, that was the reason I kept it on. Okay. So, what I mean to say, this has really alerted all the inclusive framework member countries to look at the rules and then ensure that they come out with such rules which are in line with the current business models. And in fact, in 2009, there was some initiative and then started working on this. And in 2013, that draft rules of the BEPS action plans, 15 action plans have been placed for discussion among the stakeholders. And the discussion went on, and ultimately the final reports were given in 2015. And the action plans are to be segregated or categorized in such a manner that some of the anti-avoidance measures have to be brought into the domestic law of the respective countries, and some of the measures have to be brought into the tax treaties. This is how they have segregated. And some of the amendments have already come in the domestic law, like interest limitation in the form of section 94B we have in the income tax law from last 3 years. So that is how all these BEPS action plans were finalized, and the final reports were given in October 2015. So then the 15th action plan is the multilateral instrument. Whatever you are going to bring as amendments or modifications, how they have to be brought into effect in a quick manner, in a speedier manner, in an effective manner, was there as a discussion before the countries. And they have consulted a group of international experts like Philip Baker. Philip Baker is a living legend, as you know. He's a counsel to Queen of London, and a very renowned author also. He's a Barrett Law, and he's practicing in London. Along with him, several other international tax experts have been consulted, and they all advised to this OECD G20 framework that they should come out with a multilateral instrument. See, as you know, any tax treaty is a bilateral tax treaty. That means two sovereign nations come together and they negotiate the tax treaty and finalize. It's a hardcore bargain that happens between two countries, and that would result ultimately in the form of a tax treaty, tax convention, or a double tax avoidance agreement, what we call a DTAA in India. So you can appreciate that the DTAA between India and USA took as long as 25 years or more than 25 years, that is more than 2.5 decades, negotiation has gone into before the final DTA was finalized, signed by both the countries. Though India was still at a very developing stage at that point of time, and USA being a major economic force in the globe, even then, our negotiating skills never yielded, and the negotiations went on for about more than 2.5 decades. Then only the treaty could be finalized sometime in 89, 90, like that. So why I'm saying so, if at all one treaty takes an average of 10 to 12 years even for amendment. India-Mauritius tax treaty, which was originally signed in 80s, got amended in 2016 because of a double non-taxation, which is unduly avoided by residents of other parts of the world routing their investments through Mauritius, which is a known story to everyone. So even for us to modify the treaty, it is not a unilateral job. It has to be done in a bilateral way. Both countries have to agree, both countries have to renegotiate and come out with the amendments they want to bring it. Any amendment in the international tax treaty language is called a protocol, as how we call an amendment to the tax law or income tax act. It is a protocol, is the word used for the purpose of amendment in the context of double taxation avoidance agreements. So India-Mauritius tax treaty, it took almost 10 years time to renegotiate and bring the amendments to arrest the double non-taxation of capital gains tax. You all know, resident of Mauritius having shares in an Indian company, having maintain the investment for some time, and if he wishes to exit the investment, whatever he sells share is liable to tax only in Mauritius as per the old treaty, what I'm trying to explain. And it was not taxable in India. India has categorically sacrificed the taxing rate on capital gains. And in Mauritius, at the time when the treaty was signed, there was capital gains in a very nominal way. Even that nominal capital gains has been done away with 3 years down the line after signing the tax treaty. That way, that shares that are sold of an Indian company by a Mauritius resident were neither taxed in India nor in Mauritius. It's a classic example. It was a classic example of double non-taxation. See, any tax treaty is meant to relieve juridical double taxation. Suppose a Indian company is having a branch in US or UK, the branch earns profits there. The branch is subjected to tax there because the branch is utilizing the public infrastructure there and trying to do business along with the residents of that country. And even a branch would be subjected to tax by that country as the first taxing right. So whatever taxes you pay in respect to the profits earned by such branch would be given as credit when the branch profits are consolidated in India. The company being resident of India, the global profits would be brought to tax in India. And accordingly, whatever taxes that are paid there would be given a credit in India. Why I am saying so? The whole purpose of a double taxation avoidance agreement is no income should be taxed twice. Two jurisdictions come together to tax the same branch profits of the Indian company, which is there in US. So that is how the taxes paid in US were given as credit after consolidating the branch profits in India. That is how the double taxation relief is administered in the form of tax credit. So the whole objective of a double taxation avoidance agreement is to avoid double taxation, without which the cross-border trade and investment would not happen. No person would be ready to pay 2 times tax or a double tax in 2 jurisdictions. So every country would like to facilitate relief of double taxation to promote their cross-border trade and investment. So the purpose of double taxation relief is the award purpose or the award objective of DTAA, and it should not be abused in a manner that there is no tax paid at all in either jurisdiction. So the double non-taxation was a real tax abuse, tax treaty abuse, which needs to be arrested. So that is how, as I explained to you, Mauritius is a classic example for our understanding. No Mauritius resident has invested in India to avail the benefit of that capital gains tax relief. It was all availed by the advanced countries coming from Europe and US who have invested, who have made their investment through their entities, through 100% owned entities set up in Mauritius. And Mauritius had got a law to issue tax residency certificate just to a company if it is registered there, irrespective of who are the shareholders. So they will immediately give a tax residency certificate, which will entitle such company to access India-Mauritius tax treaty. That was what has happened for more than 2 decades, 2.5 decades. Of course, the positive side of this particular capital gains tax exemption has brought in 100 billion investment to this 100 billion US dollar investment to this country, and it has created a lot of economic growth. That is the positive side of this one. The flip side is we would have lost some legitimate tax revenues, which created a furor among the revenue authorities, and they started renegotiating the treaty. Why I have explained all this? See, this is a classic example of treaty shopping and a treaty abuse. So third country residents trying to access India-Mauritius tax treaty to avail tax exemption is not exactly meant for them, or not intended benefit for those people who have availed that. So that is what is discussed by the Honorable Supreme Court in the Azadi Bachao Andolan's case. Supreme Court said the present structure of the DTA of India-Mauritius allows even outsiders to access that. you try to plug out the loophole, amend the treaty. That is on that basis, again, government started negotiating. This case was decided in 2006 by the Honorable Supreme Court. And in 2016, the India-Mauritius tax treaty got modified, plugging out the loopholes. So this sort of treaty shopping must be arrested across the board in respect of any tax treaty. There are as many as 3,000 tax treaties in the world. And if at all you have to modify these tax treaties, bringing out these anti-avoidance measures, it takes not less than 20 to 30 to 40 years. So by that time, as we have seen, it has taken 10 years for us to modify the Mauritius tax treaty, because it's not a unilateral act. Both countries have to sit together and then take a decision and then implement it. So modifying as many as 3,000 tax treaties would take not less than 30 to 40 years. And the international tax experts suggested multilateral instrument is the best option, which must be experimented, whereby all countries who are willing to bring in these anti-avoidance measures in the existing treaties must sign the multilateral instrument. And in fact, this is a very innovative experiment and achieved by OECD. It's a great success on the part of OECD, achieving this multilateral instrument as a reality. In 2015, when the final reports were given, action plan suggested about this. And then in 2016, they have brought out the pro forma agreement of multilateral instrument. And then in 2017, on 7th of June, it became a reality by 67 countries. In the first batch of signatories, India was also there, and it was signed in Paris. France, and where OECD is headquartered. There, and later on, as mentioned by our chairman, Ms. Murali Krishna, the signatories have come to almost 200 now, and now it is a reality. In India, the multilateral instrument has become a reality by carrying out the legal process and notifying the same. So this is the agenda, what I'm going to quickly discuss today. And these are all the action plans which I have discussed. 1 to 15 are the action plans. In this, we have got some minimum standards. What do you mean by minimum standard? Minimum standard is such measure which needs to be implemented by each and every country in the inclusive framework without any sort of compromise. That means that is irreconcilable measure. What are those measures? It is with reference to prevention of treaty abuse. What I explained till now, every country would like to collect legitimate tax revenues. No country would like to lose the tax revenues. Accordingly, every country is all willing to implement this minimum standard of prevention of treaty abuse. Taxpayers' grievances in the context of tax treaties must be addressed and resolved on a timely and an effective manner. See, as we know, Article 25 of the Model Convention, in any treaty you have got an article by name Mutual Agreement Procedure. This is a parallel dispute resolution mechanism we have, along with the appellate framework what we have. Even this is a parallel dispute resolution mechanism, which will happen between two competent authorities of the countries. Competent authority is a person who is authorized by the government to negotiate the tax treaty. We have a person by name, one Mr. Das is there. Now earlier it was Rajat Bansal. He is a joint secretary cadre, and he sits in the revenue department, and he is authorized to negotiate tax treaty. There are around 4 competent authorities, 4 joint secretaries to take care of the East and to take care of the West. You would have heard the name of Prajna Saxena, one lady officer. Now she got promoted and moved out. Same way Rajat Bansal got promoted and moved out. Rajat Bansal was taking care of the the East, and Prajna Saxena was taking care of the East and all that. So these are the authorities who are competent to negotiate tax treaties. The same authorities also were given the power to resolve disputes. They are called the competent authorities. But that process was not really effective, and it was taking too long a time to resolve disputes, which is not really effective. Now the minimum standard says even the taxpayers' disputes through MAP process must be speedier, and it must be time bound, and it must be effective. So that is how they're trying to balance. On the one side, they're trying to arrest the treaty abuse, which is a minimum standard. In the same breath, they're talking about how you protect the taxpayers' rights, how you protect the interests of taxpayers when there is a genuine grievance, how you address such grievance and resolve the disputes. So these two are the minimum standard, and the other standards are not mandatory standards. Minimum standards, as I told you, these are the mandatory standards which need to be implemented by every member country in the inclusive framework. Whereas the other actions like Action 7 to Action 10, these are all optional standards which are given to the wisdom of treaty partners. Suppose we have India-Singapore tax treaty or India-UK tax treaty. Both of us, that is India and UK, will think over whether they should bring out these optional standards as amendments or modifications to the existing India-UK tax treaty. If both agree, then only an amendment will come. If one agrees, the other treaty partner doesn't agree, nothing happens, and the existing tax treaty provision would continue to apply. And there are also some measures like Action Plan 4 limit, that is limiting the interest payments. As you know, interest limitation is a thin capitalization rule. Such rules have to be brought as amendments to the domestic law, and they cannot be administered through the tax treaties. So that is how Action 4 is now implemented in India by bringing 94B as an interest limitation provision. That means if at all an Indian company is having non-resident investors, that is the associated enterprise outside, and if they have infused more of debt and little of equity, and that means whatever interest they are collecting from the Indian company would be a charge here, and it would reduce their taxable profit. So there could be cases where the equity is like 1 and the debt is like 9. Out of 10 units, what they have, or out of 10 components of or 10 measures of investment, if one measure is going into equity and 9 measures are going into debt, that is a skewed investment, and the debt would be recharacterized as deemed equity, and the interest would be disallowed. Beyond 30% of the EBITDA, it is going to be disallowed as per 94B. This is how the action plans need to be implemented partially through domestic law of the respective countries, and some of the measures like Action Plan 7, which deals with the permanent establishment, and Action Plan 2, which deals with the hybrid mismatches, and Action Plan 6 and 14, 6 and for both minimum standards, all these have to be brought in through the tax treaty network. And that is how multilateral instrument is tried as the best option to bring out these amendments to all the tax treaties that are existing in a very speedier manner. Okay, and then the journey of multilateral instrument for India, October 2015, as I mentioned, the final report has been submitted, and November the crux agreement, the crucial discussions have happened, and the MLI's pro forma has been released, framework agreement has been released, and then in June 2017, it has become a reality by the signature of the first batch of signatory countries like India. And then on 25th June 2019, MLI has been ratified through the legal process in India. And on 9th August 2019, MLI has been notified by the Ministry of Finance, and it became effective from 1st of April 2020. So we need to know how MLI is going to operate now. See, all through, if there is an issue, in the context of India, UK or India, Singapore, just for the sake of example, we were looking at the treaty, the protocol and other explanatory, other what you say, technical explanations or memorandum of understanding, if anything is like that, which is annexed to the tax treaty, that we are examining to arrive at the legal position of taxation of a non-resident in the source country. But now we need to look at MLI and how MLI has amended or modified these existing tax treaties is what we need to bear in mind along with the original text of treaty what you examine. And the structure of MLI is something like this. Part 1, it talks about scope and interpretation. Part 2 is like hybrid mismatches. Hybrid mismatches, most of that happen in other countries. In both countries, a particular receipt would be exempt. In one country, it would be treated as interest, and in one country, it would be treated as dividend, which at hybrid mismatches, somehow in our country, we didn't allow from the beginning. That way, we were not much bothered about this hybrid mismatches. And even transparent entities, UK has got a system where partnership is not an opaque entity, it's a transparent entity. In the sense, partnership firm is not a taxable entity in UK. It is only the partners who are going to be taxed. Whereas in India, partnership is also a taxable entity and partners are also a taxable entities. And then treaty abuse is the most important objective we need to achieve. That is Article 6 to 11. It carries all the measures what are being proposed and accepted now. Now MLI is a reality, and that Article 6 to 11 would talk about how we are going to prevent treaty abuse. And the permanent establishment is part 4. What are the changes that are going to come in? And improving the dispute resolution is a mandatory standard. Again, as I said, it's a minimum standard. Article 16 and 17 talk about it. And arbitration, for your knowledge, I would mention, arbitration is another process through which the disputes regarding tax treaties would be resolved. What I mean to say, first of all, you were referred to the competent authority, as I mentioned to you earlier. Suppose a US company has got its subsidiary in India, and subsidiary has gone through some transfer pricing adjustment. Then the parent company in USA can move the competent authority stating that this particular TP adjustment which is made in the hands of my subsidiary there needs to be deleted because that is not done as per the agreed approach of transfer pricing regulations or the economic analysis. So that is how both competent authorities of US and India would try to resolve this issue. Okay, so that resolution is not happening in a time-bound manner. Sometimes it is taking 5 years, 6 years, 7 years, 8 years, which is of no use to the multinational enterprises. That is the reason now there is a proposal that whatever that is referred to the competent authorities must be addressed in a time-bound manner of 2 years, and if it is not resolved, then it would be referred to arbitration. Arbitration would be taken up by third country authorities. Suppose it's a India-UK dispute, it would be taken up somebody by US authorities or some third party who is agreed upon, who has been appointed and as agreed as an arbitrator by both the countries. So India is somehow against this concept, and India is of the strong view that it infringes our sovereign right of dispute resolution, and India has not agreed, India has not opted for arbitration. That is the reason arbitration part of it is not a minimum standard. It's an option that is available. Most of the advanced countries have gone, US and other countries have gone for arbitration, but India is against that. And that is the reason arbitration articles are not relevant to us. And then final provisions, that is like procedural provisions you have. And then let us quickly get into the entire structure of MLI. See, you have, as I mentioned, part 1, part 2, everything is there. Whatever there is there in green color, that is the minimum standard which needs to be implemented by each and every country of the framework who have agreed to sign the MLI. And then the transparent entity, that is in the brown color is an option, and India has opted out of the transparent because we don't have any transparent entities in India. Partnership is an opaque entity, it is a taxable entity, and also the partners, unlike what is happening in UK. So this is how green color are minimum standard and brown are all options. And let us get into the subject proper. So how an MLI is going to operate, how it is going to modify the existing tax treaty is a very interesting discussion we are going to make. Each signatory to the MLI indicates its position as to what tax treaties it would like to cover. On 7th June, when India has signed as one of the signatories in the first batch of the countries who have signed the MLI, we have notified all the existing tax treaties, as many as 93 tax treaties. Later on, we would have signed 2 or 3 or some more tax treaties, but all those new tax treaties have been signed in a manner that these anti-avoidance measures have been incorporated in the new text of the treaties. So the old treaties which require real modification were brought under the purview of MLI by India. The same way, each country will bring its respective tax treaties as covered tax agreement. When you notify a particular treaty so as to be impacted by the MLI and the amendments that are brought in, that is called a covered tax agreement. That means covered tax agreement is meant to undergo the required modification on the basis of the MLI provision. So here, as you must readily understand, MLI now around 100 countries, more than 100 countries are coming together and signing one instrument. That instrument must do a multifarious act of amending as many as 3,000 tax treaties. That is the objective. So when we have notified 93 tax treaties, Mauritius is one country who has not notified India-Mauritius tax treaty as a CTA. Then what happens? India-Mauritius tax treaty would not undergo any change on account of MLI. Unless the treaty partner also comes forward and then signs MLI, and both treaty partners make the same options, then only a particular article in the tax treaty would get modified. Otherwise, no. And because always it is the sovereign right of the nations to negotiate and come to a understanding, as I explained, with USA, we negotiated for more than 25 years to sign the treaty. So that right is always protected and that right is not infringed. The bilateral rights of both the countries, that is always protected. Having signed MLI, having brought the required amendments to the existing treaty, in future, the treaty partners are always at liberty to negotiate, to renegotiate and bring any sort of amendments they would like to bring, except the minimum standards. Minimum standards, treaty partners themselves would not try to disturb because minimum standards are going to help them collect legitimate tax revenues. They are not going to compromise on that. So other options, what they have taken through MLI can always be modified, altered in future through bilateral negotiations. That is how whoever is coming as part of the inclusive framework and signing the MLI are not restricted, and they will always enjoy their sovereign right to renegotiate any of the options if they want to modify. And the signatories can amend their MLI positions until ratification. Ratification is a legal process which is explained by our chairman in the introductory remarks. Then only your positions, what you have taken through MLI, would become effective and legally enforceable. So such ratification is a legal process. Till such process takes place, you can always change your options. That is what is explained. A lot of flexibility is given to the countries. And MLA is not like an amending protocol. As I mentioned to you, in the international treaty context, tax treaties, you call an amendment a protocol. You don't call it an amendment. You say there is a protocol to the Singapore Treaty. There is a protocol to Cyprus Treaty. So protocol means there is an amendment. whereas we call it an amendment in the domestic law context. Okay, so MLI is not like an amending protocol to a tax treaty, which would set out amendments to the text of specified provisions of treaty. Instead, MLI is to be applied alongside the existing bilateral treaties. That means you must read what is there in MLI. You must also read what is there in the tax treaty, which is already there. Let us say India, UK, or India, Singapore, for an example I'm telling. Then you try to then figure out what positions these two treaty partners have taken with respect to various articles of MLI. And you can go into the OECD website. Matching database is the link you have to, which link I have given in the later slides. If you go through that link, you will go to the website where all the positions are stored in the database, and you would know what positions each country has taken. Suppose India, UK, USA has not signed MLI, please remember. It has participated, but Big Brother said all these anti-avoidance measures are already there in their domestic law and they have not signed. So MLI has no impact on India-US tax treaty. That is what you need to bear in mind. And MLI does not freeze the underlying bilateral tax treaties in time. The objective of MLI is not to freeze the tax treaty and say, you can't change even a letter in this in future. No, that is not the intent of MLI. As I mentioned a little earlier, the flexibility and the sovereign right of both treaty partners is always intact. They can always come out with some amendments in future to what they have agreed now through MLI, except the minimum standards. That is always a possibility which is allowed. And group of experts recommended an effective and swift way is to go through MLI so that you can bring these amendments very fast. MLI modifies any tax treaty in force between the parties to MLI, which has been listed by both the contracting. Both, suppose India, UK, both India and UK have to notify this treaty as a covered tax agreement from both sides. Then both have to make their options. If both options match, then a particular provision or article against which they have made the options will get modified. That is how it operates. And the modification is a very well deliberated choice suggested by international tax experts. The word modification is used. MLI is going to modify the existing provisions or articles of the tax treaty. So we have to always use the wording, the term modification. MLI follows the general legal principle. What is the legal principle? When two sovereign states sign two agreements at two different points of time on the same subject matter, the agreement that is signed at a later point of time would prevail over the agreement that was signed in the earlier point of time. So that is an international rule. I mean, that is a legal principle which is enshrined in Vienna Convention. What is Vienna Convention? Vienna Convention is signed in 1969 by various countries as to how international agreements have to be entered into, what are the principles, what are the rules. After entering into international agreements, how you have to honor those agreements in good faith. Even tax treaty is also an international agreement. So whatever rules that are prescribed for enactment and implementation as suggested by Vienna Convention in various articles like 26, 30, 31, 32 supplementary means and all that would apply even to MLI. And one of the rules pronounced in Article 30, subarticle 3, that is lex posterior derogate legi priori. What does it mean? That is, the subsequent agreement would prevail over the existing, the earlier agreement. And this rule is on the basis of this rule, MLI is going to operate. MLI is to be viewed as a subsequent agreement entered into between the treaty partners, that is, say, India, UK. Both have ratified their instruments, both have notified this India-UK tax treaty as a covered tax agreement, and both have given their option. Definitely that would impact and modify the existing tax treaty of India-UK. So the subsequent agreement is MLI. The earlier agreement is the DTAA. DTA gets modified to that extent on the basis of MLI, which is agreed and signed and ratified by these two countries. So the existing provisions of CTA will now be modified through mutually chosen options. There is no compulsion except minimum standard. Everything is only an option and a choice. You make a choice. If both treaty partners make the same choice, then it will get modified. If they don't make the same choice, then nothing changes the existing text or provisions of the treaty. And then modification is through compatibility clause. How this modification is achieved? Very interesting. The legal pundits will look at the compatibility clause. They said these compatibility clauses will bring the required amendment, required modification to the existing provisions of MLI. That is what they have suggested. And what are these modification, these compatibility clause? In place of, modifies, in absence of, in place or in absence of. These are the compatibility clauses that are used in the respective articles of MLI, which we will discuss in the later slides in detail. And then the explanatory statement was prepared by the participants in there. There is an explanatory statement that is also there along with MLI. MLI text you can download from OECD website. And the same way explanatory statement also you can. Explanatory statement will say there are about more than 30 articles in MLI, and they will give the background of each article and what is the understanding of all the inclusive framework participants of this MLI agenda. What is it they have understood about each and every article is going to be explained. So it has to be viewed as an understanding of all the framework partners of this agenda, and it includes descriptions of the types of the treaty provisions which are intended to be covered and the ways in which they are intended to get modified. So explanatory statement is not meant to be relied upon for the purpose of interpretation. It is not meant to be relied upon for the purpose of interpretation. It is only meant to be relied as one of the aids. It cannot itself interpret and give what is the purport of this article of an MLI. And accordingly, the interpretation of the articles of MLI also, you will go back to the Vienna Convention. That is the normal interpretative process we follow. We have Article 26, which talks about good faith principle, and we have Article 30, 31, 32, supplementary means, all these principles what we apply, and all these articles of Vienna Convention what we go through for the purpose of interpreting the tax treaty is the same approach what you need to follow even to interpret the provisions of the MLI. That is what has been explained, and minimum standards are in the form of Action Plan 6, which talks about prevention of treaty abuse, and Action Plan 14, which talks about effective dispute resolution mechanism. These two are the minimum standards which I explained. And the compatibility clauses, which I explained a little earlier, in place of, what does it mean? If you use in place of in a particular article of MLI, that particular clause, if it is taken as an option by the treaty partners, what is it's going to do? That in place of compatibility clause will come and then replace the existing provision of the treaty. There must be an existing provision, then only this would apply. If at all the targeted existing provision is not there in a particular treaty, this has no relevance. Same way applies to or modifies. What do you mean by applies to or modifies? That means there is one provision which need not be replaced, but it has to be modified to some extent. That also applies only if such provision is already existing in the treaty. If it is not existing, it is not going to be applied. Then you have in absence of, that means we require to have, we want to have one particular provision to protect the interests of the countries, but that particular provision is not there in the existing treaty. That means if it is absent in the existing treaty, then only this compatibility clause related article would apply, otherwise it would not apply. But whereas if you go into the all pervasive compatibility clause, that is in place of or in absence, so that means it is going to cover all situations and there would be no exception. And this would apply in the context of minimum standards, because minimum standard is one amendment or modification which every member of the inclusive framework have agreed to implement without any compromise. So it's a irreconcilable agreement to be implemented by the inclusive framework partners. So this particular all powerful compatible in place of or in absence of means it would cover all sorts of treaties, whether you have that provision or not. If there is a provision, the new article of MLI would modify it to the extent it is incompatible. That is what it says. With respect to these articles, by any chance, if the treaty partners have not notified by mistake, which needs to be really get modified, but by mistake they have not notified, even in such situations, articles which have this language of the compatibility clause of in place of or in absence of would apply and modify the text of the provisions of the existing treaties to the extent such text is incompatible with the article proposed by or article which is there as part of the MLI. And reservation, what is a reservation? I'll just have some water. What is the reservation? As I mentioned, to accept minimum standards, all other articles are options. No one is compelling you to say yes. If you feel that you require that modification, and if your treaty partner also agrees to that, both have come to the same understanding, both have made the same option, then it would get modified in the existing treaty. So that way you can always take a reservation. That means you are opting out. You are not opting in. You are opting out. You say, I don't want to have this particular provision of the MLI. Then no one is going to compel you. That is called a reservation. Reservations are the flexible, the reservations are the, indicate the flexibility that is available to each nation as to they can make their own decision whether that particular option is to be availed or not. Then what is the notification? Next is notification. Having opted, you wanted to have a particular article and you wanted to change permanent establishment rules on the basis of the MLI article. Your treaty partner also has agreed. Both have agreed to that change. Then it would be notified by both of you in the ratification instrument. Then it becomes enforceable. So as I mentioned to you all through, unless both treaty partners agree to the same option, there cannot be a modification or amendment to the existing tax treaty with respect to any particular article. But there is one situation where both treaty partners can take different options, but still it would operate. That is only one article, that is Article 5 of MLI, which is called an asymmetrical provision. Asymmetrical provisions operate in such a manner that options of the treaty partners are different, still it would operate in an effective manner. This will happen only with respect to elimination of double taxation, Article of 5 in MLI. Elimination of double taxation, how, as I mentioned to you, I gave an example of Indian company having a branch in USA, branch profits get taxed in USA, and you pay taxes there, which taxes are given as credit in India when you consolidate USA branch profits in the Indian company accounts in India. That is called the credit mechanism. There is also another mechanism to avoid double taxation, is called the exemption method, which is the most ideal method, but now rarely used. What is exemption method? If at all your branch of the Indian company in USA is taxed, the branch profits are never considered for the purpose of taxation in India. That is called exemption method. We have such exemption method only with a treaty like Greece we still have, but we are not encouraging any sort of exemption methods in any of the treaties now. By and large, we follow the credit method. That means taxes paid there would be given as a credit for against the overall taxes that are calculated, including such branch profits in the consolidation. So one country may take exemption method as their approach, and the other country may take credit method as their approach. Still, it would operate only in this context, which is called an asymmetrical provision. That is Article 5. Because now there's no problem. Suppose India, Singapore, I'm just giving an example. India, Singapore is not following the exemption method. I'm just giving an example. If suppose Singapore says, I would follow exemption method, what happens? Exemption method means if Singapore residents earn income in India, which is taxed, then Singapore will not include that income in Singapore for tax purposes at all. That is called exemption method. If India follows credit method, we will say whatever taxes you pay there, that would be given credit. If you have not paid taxes there, the entire income would get taxed here. So both countries can have different methods, still it would operate as a provision. That is called an asymmetrical provision. And BEPS Action Plan 15 and text of MLI, these are all the aids to interpretation, how you interpret the provisions of MLI. And BEPS Action Plan 15 and text of MLI is important. An explanatory statement to MLI, which reflects the agreed understanding of the negotiators with respect to MLI, is an important aid, though it would not by itself interpret a particular provision, but it's one of the aids. MLI positions adopted and deposited. As mentioned, the ratification instrument, as mentioned by the chairman now in the introductory remarks, we have given our ratification instrument on 25th June 2019. We have given and got it statutorily processed. And that is called the positions and deposit of the instrument to OECD. And that is important document which we need to consider. And BEPS Action 2, 6, 7, and 14 have found their place in MLI. As I mentioned to you, all the action plans cannot be implemented through tax treaty network. Some of them come into the domestic law. Some of them have to be implemented through the treaty network. Text of the existing tax treaty along with protocols, if any, are also important aids to the interpretation. The existing tax treaty, definitely we have to go through what is there in that. And then OECD Model Convention got amended on the basis of BEPS action plans and the final report. That substance has been brought in, and whatever that is brought into MLI, the Model Convention now, hitherto whatever treaties you are going to enter, that treaties are based on the revised model framework which carries the BEPS measures. The synthesized text of MLI between parties to a CTA. What is a synthesized text? Synthesized text means India, UK, having ratified their instruments with OECD and having brought in MLI into effect in the respective countries through their legal process, then they will issue a synthesized text, means they will give the text of the DTA or the tax treaty, giving the whole clause, and also they will say which article got modified and what is the modification. Everything you can see in the entire text. That is like a ready reckoner. You will understand how the India-UK tax treaty has undergone the change. Same way, we have list of synthesized texts what are available as on date with us. And MLI matching database is very important, through which you will know what positions each country has taken. List of the countries having DTA with India and also ratified MLA as on 8th June 2021. As many as 49 countries, treaty partners of India, have also ratified their tax treaty. That means all these 49 tax treaties are going to be modified as per the options taken by the India and the respective treaty partners. And synthesized text I have explained to you. And synthesized text is not a legal document. It is just a suggested approach to make, it's a facilitating document. You will understand what changes have been brought in by MLI. So this is not, they have, OECD has not prescribed any format. It encourages countries to bring in synthesized text so that it would help, the taxpayers in understanding quickly what modifications MLI has brought to the existing provisions of the treaty. There is no legal obligation, as I mentioned. This is a suggested approach and no official format to develop synthesized text on the MLI, and synthesized text also to include an explanatory statement and also in the form of a disclaimer. And they have to, what disclaimer they have to put? Following are the key general disclaimers. What they say: MLI CTA means the existing tax treaty, and the latest MLI positions of the parties along with the hyperlinks. They have to make a reference to that in the synthesized text. And synthesized text has no legal value. It's not a legal document for us to rely upon for the sake of interpretation. And statement that the MLI provisions could take effect on different dates depending on the provisions in question, types of taxes involved, and the choices made by each contracting jurisdiction. You will mention, but there is no binding effect of the synthesized. That's not a legal document, but definitely MLI is a legal document. Existing treaty is a legal document, and the entire, the process or the documents you have is a legal document, but not the synthesized text. And list of countries with whom we have the synthesized text are as many as 27 as on 8th of June. That is including Cyprus. We have synthesized text, which you can know by visiting the CBDT website. Then, how this MLI is going to be effective? MLI would come into effect in two different ways in respect of two different items of tax. One is withholding taxes. The other one is the regular taxes. With respect to withholding taxes, a particular effective date will be applied by both the countries. With respect to regular taxes, another date would be applied. Because the withholding tax date should always precede the regular taxes date, because the transactions start happening after MLI becomes a reality. So the entry into force is always different from the date of effective date, from the effective date. Effective date is different, entry into force is different. Because we have two different tax years, India follows financial year and most of the countries follow calendar year. The effective date cannot be the same. Same way, entry into force might be two different dates depending on the respective statutory legal ratification process each country takes. So as far as when, suppose take the example of India, Singapore, the entry into force would have happened on two different dates, which we will see in the next slide. What is the latest date? Suppose India would have brought entry into force at a later point of time compared to Singapore. So that latest date of the treaty partner would be considered. From there, what is your taxable year? When is the taxable year going to start? After that, from first day of the taxable year, withholding taxes would be applied. This is how it's going to operate. So let us go to the, as far as the regular taxes is concerned, 6 months from the end of the entry into force, latest date of entry into force, from there it would be calculated. If you look at an example, you will understand. India, as I mentioned, on 25th June 2019, it has completed the legal process of ratification. And whereas Singapore has completed on 21st December 2018. But whereas entry into force is the next column, On 1st October 2019, it has come into force as far as India is concerned with respect to India-Singapore Treaty. But whereas in Singapore, it has come on 1st April 2019 itself, because their ratification has happened almost 6 months prior to what we did. But entry into force, the latest date of entry into force is, that is the later date, that is 1st October. From there, you have to see our taxable year when it is starting. From 1st April 2020, withholding taxes will apply. For Singapore, when is their taxable year starting? After the latest date, after 1st October, that is 1st January. 1st January itself, they will start applying withholding tax rates as per the MLI, impacted tax treaties. Then other taxes, it is 6 months from the end of the latest date. 6 months from end of the latest date, again, luckily our effective date is 1st October. That is the later date compared to April brought in by Singapore. From there, 6 months is, what 6 months means? From there, 6 months means it is again 1st April 2020. So on 1st April 2020 itself, even for the regular taxes, India-Singapore Treaty would be effective from the Indian perspective. Whereas for Singapore, it would be 6 months from the end of the latest date, that is 1st October, that means 60 months is 1st April 2020, but their taxable year starts on 1st January. So what is the next taxable year which is starting after 1st April 2020, that is 1st January 2021. On that date only, the taxes would become effective. Regular taxes would be effective from the MLI perspective. And interpretation of tax treaties are governed by public international law. Common interpretative principles are enshrined in Vienna Convention. As how you interpret a tax treaty, you need to interpret same way even the MLI provisions. And these are all the important articles of Vienna Convention. That is a good faith principle. That means both countries have to honor an international agreement. Then only the agreement has some meaning. If both start violating the agreement, then there is no meaning to that agreement. And Article 30 or sub-article 3, I have explained, this is the principle on the basis of which MLI is operating. And Article 31 is the general rule of interpretation as per for the treaties. The same thing would apply even to MLI. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms thereof in the context and in the light of its object and purpose. Okay, and 32 is the supplementary means. That means you will have to look at what are the, if there is the ordinary meaning is not coming up, then you will have to look at the text of the treaty and what has been exchanged between both the countries. As I mentioned, India-US negotiated for 25 years and then concluded the treaty. Then you will have to go through what mails got exchanged, what letters got exchanged, and what views got exchanged, and ultimately what is finalized. Then only you will know their true mind and their true, what they have truly agreed. And we are now coming to the last portion of the case studies. I will run through case studies quickly so that we'll have some time for discussion. And I'll just break here for just 5 minutes and then come back, Mr. Murali Krishna. Is it okay?
Yes, sir. Okay, sir.
Yes, I'm giving a break for 3 to 5 minutes.
Okay. Okay.
సార్ చైర్మన్ గారు సిఏబిఎఫ్ గురించి అనౌన్స్ చేయండి సార్.
అట్లాగే సార్.
ఈ లోపులో
అలాగే అది రెగ్యులర్ అనౌన్స్మెంట్. Dear members, regarding CABF, I hope you all know that we have started one mega drive to collect around 100 lakhs from our branch and give it to ICI, which will be very helpful to the needy people in this pandemic. So I request all of you to come forward liberally and contribute for this noble cause, so that we will send from the branch side one single check for the full amount with the details of members' names and membership number and the CABF number, life number, all those details we are going to submit to the ICA. So I request all of you to come forward with your liberal contributions so that we can reach our expected figure and give this lump sum amount to ICA. Dear members, one more announcement. We, the Visakhapatnam branch, is planning to conduct a GST workshop for 3 days for 9 hours of CPE on 25th, 26th, and 27th of this month. That is next Friday, coming Friday, Saturday, and Sunday. The timings are morning 10 to 10:30, inaugural proceedings. From 10:30 to 1:30, 3 hours complete session on the topic, including question and answer session. So in this, eminent speakers are addressing us. So I request all of you, please join and make best use of this workshop. The first day, CA Anchal Kapoor is the speaker from Amritsar, and she will be dealing on constitutional aspects and recent judicial pronouncement. And on that day, inaugural session, CA Rajendra Kumar sir, who is the chairman for GST and Indirect Tax Committee, will be the chief guest, and they will address our members. And also our Central Council member, CAD Prasad Kumar Garu, who is the program director, will also be addressing all of us. And the second day, that is on Saturday, 26th, CA Atul Kumar Gupta Garu, our immediate past president of ICA, will be taking up the session on input tax credit. On that day, Saturday, from 10 to 10:30, inaugural session, chief guest will be Sri N. Srinivasarao Garu, Joint Commissioner of Commercial Taxes. He will be addressing our members from department side. So whatever we have any doubt, we can interact with them and we can get clarifications from the department side. The third day, Sunday, 27, we have third day session for 3 hours. CA N.K. Bharat Kumar from Chennai will be addressing our members on the topic show cause notices, replies, and representations. So the entire 3 days, we have specifically chosen most important topics and chosen eminent speakers for this subject. So I request all of you to register for this 3-day GST course workshop and get maximum benefit out of this workshop. With your doubts, worries, all those things, you can interact with the speaker and you can get clarifications then and there. For this, there is no fee for the one-time annual fee paid members. For other than those who have not paid one-time annual fee for this year 21-22, 700 rupees plus GST will be the registration fee for this workshop. So I request all of you, make note of this and block your calendar accordingly. The details with the flyer and information will be followed shortly. And we are sending Google Forms in this regard. Please fill your details and register for this workshop and attend and make it a grand success. We, the Visakhapatnam branch, are planning to conduct many such programs, but we need the member support in the form of attendance. A good attendance will motivate the branch or managing committee to conduct the programs more and more. Even for the speakers coming across the country also will be comfortable in addressing when there is a good number of delegates and queries or questions from the delegates. Thank you, members.
Shall we continue?
Sir, yes, sir, yes, sir.
Or if you still have some announcements, I will wait. There is no.
sir. No, no, just the time you have just utilized.
No, you are rightly availed the time. You are rightly availed so that it was not kept silent. So you have really utilized the time. So coming to case studies, I will quickly run through case studies. F Company is a Singapore company having a warehouse and customers in India. It's an e-commerce company, as you know, like Flipkart or Amazon. What is happening is the orders are getting fructified online and then delivery is happening. And as you know, Amazon, Flipkart now operate with the fulfillment centers. Originally, in all the treaties, the storage and the delivery function was not treated as a revenue rising activity, especially in the OECD model convention. But India always canvassed that delivery function is a revenue rising function. Accordingly, UN model convention also supports the same. So here, in nutshell, what we are going to discuss is based on the old approach of treating storage and delivery as an auxiliary activity, that is a preparatory activity, no taxes were levied. Taxes were levied only on the basis of contract conclusions. But now the business models have changed. Because of the digital age, you make e-commerce transactions, you book online and get the deliveries. So it is no more a preparatory or an auxiliary activity. And this function needs to be understood as a revenue raising activity on the basis of change in the business models of e-commerce models. So the old approach would no longer would be applicable now. And India-Singapore tax treaty, luckily, they did not opt for any change in the PE related clause. In the PE article, you have this auxiliary activities and exempt activities. There is no change, but the very existing provisions have taken care of this particular issue. If at all the delivery is occasional, then only it is auxiliary activity. If it is a regular delivery, then it is liable for tax in the country where it's happening. So in a source country like India, a Singapore company having its web portal, online business would get taxed to the extent the business is recorded with the Indian customers. So that is what is the essence of the first case study which I have brought in here. And coming to the second case study is a peculiar case study where you have a parent company has infused its equity into an Indian company, that is the parent company has a subsidiary in India. Parent company also gave a loan to the Indian company. That loan between parent company and the Indian company, the interest payment is happening. Parent company, what it does, it has parent company holds entire share capital. When T company is a company which is in another jurisdiction, acquires all the shares and debts from the parent company. There is no tax treaty between country T and India, on account of which maximum withholding tax rate as per the domestic law would apply, Indian domestic law would apply. So that is a very undesirable consequence in the international context for the multinationals. So what T company has done, T company transfers the entire loan to N company. N company is situated in Netherlands. We have a particular provision with the India-Netherlands treaty stating that if you receive loan from a particular category of lenders, the interest what is to be paid by the Indian borrower would not suffer any withholding tax. That is what is there in the India-Netherlands tax treaty. So because you have intentionally restructured the loan and sold it to a Netherlands company to avail this benefit, whether this would be undone by the principal purpose test of the India-Netherlands tax treaty, because principal purpose test is a minimum standard, as I mentioned to you. That is what is the issue. Definitely, that can come under the scanner of the principal purpose test is almost like your GAR. It would get applied, and accordingly, the benefit might be denied. That is what we need to understand on the basis of MLI. Then case study 3. This is a live case where you have a fast moving consumer goods company from Japan, like Daikin. It's a live case. It has its own subsidiary in India, and subsidiary employees, what they are doing, they are negotiating with the customers, they are identifying the customers, they are doing everything except signing the contract. The signing contract is happening at the parent company level in F company online, except that everything else they are doing. On account of which they were trying to avoid the trigger of PE. The earlier wording of agency PE says, unless the agent has got an authority to conclude contracts, it would not amount to a permanent establishment. But if agent is doing everything except signing the contract, he has done everything in substance. So now the MLI says that is not possible. Of course, in Daikin Industries, much before MLI could be applied, Daikin Industries Delhi Tribunal held that Indian company is a subsidiary of Indian company being a subsidiary is an agent of Japanese company, and to that extent, the Japanese company would be taxed in India. That is what is held in 2018 by the Delhi Tribunal. The same concept is a substance over form approach is what is suggested by MLI. And Article 5.7, originally this is the article, this got changed because of the India-Japan synthesized text you see. And that synthesized text says, not only the authority to conclude contract, if habitually plays the principal role leading to the conclusion of contracts, that is good enough to trigger PE for a foreign company in the source country. And the agent would be a dependent agent, and dependent agent permanent establishment would come into play. And then case study 4, F company is incorporated in Singapore, and Singapore I company is a subsidiary of F company. F company invested in its shares before 1st April 2017. As you know, what we have discussed about Mauritius, about the double non-taxation, that benefit was there with Singapore also along with Mauritius. That benefit got removed along with Singapore Treaty, even the along with Mauritius Treaty. When Mauritius Treaty got modified in 2016, at the same time, Singapore Treaty also underwent change. They have put a threshold and they have put a cutoff date, 1st April 2017. Whatever investments that are made prior to 1st April 2017 would be allowed to avail that exemption of tax. That means virtually there is no tax in India for the shares held in the Indian company when they are sold. It will be taxed only in the country where the alienator is a resident. So that way the tax residents of, because there is no capital gains tax in Singapore, there is no tax there, it's a double non-taxation. So that benefit is restricted to all investments which are made up to 31st March 2017. Even in the GAR provisions, it has been clarified through a circular that these investments made prior to 17 March are grandfathered. Grandfathered means they are not going to be touched. Whatever investments that are being made on or after 1st April would come under the new provisions and they would be taxed. So the now question is, whatever that you have invested in the past, if it is getting sold after 1st April 2020 and before 1st April 2020. Before 1st April 2020, MLI is not there. So revised provisions of Singapore Treaty will apply. Even GAR provisions have clarified that GAR would not be applied. So there is no problem. When you sell something after 1st April 2020, principal purpose test also has come into effect from the Singapore Treaty. whether that would be applied, overruling GAR exemption what is given, and then accordingly, would the benefit be denied is the question. That is the crucial question we need to answer. Because this is a well deliberated modification done in 2016, and both treaty partners have signed the MLI having this in mind. And then the MLI, the principal purpose test article also talks about, this is the notwithstanding any provision so and so, so and so. If it is reasonable to conclude that regard obtaining benefit was one of the principal purposes, that is the principal purpose test would be applied. But it has given an exception stating that granting that benefit in these circumstances would be in accordance with the object and purpose of the relevant provisions of the agreement. If at all it is agreed upon by both the treaty partners that this exemption or benefit must be given, and if it is in accordance with the object and purpose, then it would not be hit by the principal purpose test. So definitely, because India, Singapore has renegotiated and have given the grandfathering provision. So such grandfathering provision means accepting all investments made prior to April 2017 would be exempt from any sort of tax. So that exemption would be protected and it would be available. Case study 5, it's a clear case of tax abuse, treaty abuse. You have an IP holding company in country R. If it gives its IP license to operating subsidiary in country S, then there would be a withholding tax. To avoid that, what it is doing, it is giving licenses to a conduit company in country X. Country X in turn is giving it to the operating company subsidiary in country S. The treaty between country X and country S says that there would not be any withholding tax against the royalty that would be paid for the license they take. So this is this restructuring is having only one purpose or object to avoid tax, which can come under the scanner of principal purpose test of the MLI, and then this can be recharacterized and the benefit can be denied. And then the last case study is, this is again one agreed upon provision in the India-Netherlands tax treaty. In this case, F company in Netherlands is holding shares in India, Indian company. F company sells its investment in I company to its group company, R company. See, India-Netherlands tax treaty carries a provision. If at all there is a restructuring in the group, same group, one company sells its investment to another company, such investment should not suffer tax in the source country, that is India. This is a live case again, Vandenberg Facilities, which is a Hyderabad-based company, and Andhra Pradesh High Court has endorsed this exemption as per the treaty provision. Now the question is, in the post-MLI period, whether this provision would be protected or not. Definitely it would be protected because it's a bilateral agreement. This article is not amended. This article continues in the tax treaty of Netherlands. Though principal purpose test is there, this would fall under the exception, that is the carve out of the principal purpose test, and PPT will not have an application here. This is how, friends, I thought I would explain the MLI provisions in a very simple manner without confusing you. And this is what I wanted to bring in this session. I'm very thankful and I would be happy to deal with some of the questions.
Sir, there is one question from Kamashastri garu.
Yes, yes. Kamshastri is my good friend.
Yes, sir, yes, sir. Will asymmetrical approach not apply to financial year and calendar year?
Asymmetrical approach?
Not apply to financial year and calendar year.
Not applied to financial year and calendar year. No, I could not get his question.
Sir, that is.
Mr. Prasad, good evening.
Yes, Mr. Kamshastri,
When
Chapalli.
you were talking about asymmetrical approach, you talked about Article 5
Yes,
of the MLI.
yes.
But subsequently, in the clarifications determining the entry into force and entry into effect, you have explained the asymmetrical approach of the taxable period also. Say, for example, between India and any other foreign country, India has got the taxable period of 1st April to 31st March, whereas most of the countries do have the calendar year.
Correct.
So that is also an asymmetrical approach which is acceptable. And so furthermore, the 30-day period,
Pardon?
30-day gap after the period also, after the what you call signing in and ratification, 30-day cooling period is being taken by India. Even the opposition party doesn't take the other party doesn't opt for it also. There also that asymmetrical approach is accepted too, if I'm not wrong.
Yes, yes. See, asymmetrical approach, as you rightly say, when you are allowed to have different approaches, that is asymmetrical approach.
Yeah.
When we come to the provisions per se, Article 5 is the only provision where each treaty partner can take their own options still. So as you rightly say, having different taxable years is also an asymmetrical approach. There is no doubt about it. There is no doubt about it. But strictly speaking, with respect to provisions of MLI, Article 5 is one provision where the asymmetrical approach is allowed to operate.
Today, we are having the CTC RRC.
Acha?
CTC RRC.
Okay, okay.
Padams on Nexus.
Okay. Acha.
I had to break that and come back to you.
Pardon? Okay,
I
okay.
had to break, disconnect from there and come back to you.
No problem, no problem.
From there it was from 4:30 to.
Acha.
And it was supposed to close.
Okay.
But as you know, Padam and Chaitanya.
No, it would pull on for hours together if they are allowed.
Days together.
Days together, correct. So
After a long time.
a very long time, and how are things? And I'm very happy to virtually meet my good friends. At least physical meeting, we don't know.
Now almost presently ruled out. Presently ruled out.
Presently ruled out. Even 2021 is washed out.
Yeah.
Everyone, we thought 2021 is a hope, but second wave has washed out 2021. So till December, almost people will be like this only. We don't know about 2022.
Okay, back to you, Mr. Chairman, sir.
So, Chairman, if there are no questions, we can close the session.
Sir, another thing is, sir, you are told India has not opted for the arbitration clause.
Yes.
Then what will happen, sir? Because we have to go to the court only, international court.
No, actually, as I explained to you, the mutual agreement procedure is an alternate dispute resolution mechanism under the treaty law.
Yes, sir.
You can have your regular appellate mechanism going on, but only thing is when you agree for the decision of the map, then you will have to withdraw your appeal in tribunal or wherever it is. Okay. But what is happening, it is taking too long a time. That is the reason they have brought the arbitration provisions in MLI. But they are not mandatory. Though it is part of the dispute resolution mechanism, it is not made mandatory. Only you must give assurance that you would conduct an effective and speedier resolution process. India has guaranteed and assured the international community that they would speed up the map process. I don't know what they are going to do because the history has been very, very pathetic and cases have been, our own claims case in the map process, it took more than 8 years. And recently, on the basis of the MAPS decision, which we agreed, we have withdrawn our appeals in the tribunal to the extent of grounds already decided by the, this is also, I think this is a pronounced judgment. The name also I can give, Hitachi Consulting Services, that is the Sierra Atlantic Services, which would be reported by the tax journals also. So that is the reason, as you say, if India is not agreeing for arbitration, and if the things prolong for years, again, what is the recourse? It is very, very, as of now, that recourse is not available. That is the only recourse is arbitration, which India is not agreeing. So there is a lot of pressure on India to agree for arbitration. We don't know what would happen in the future.
Okay, sir. Thank you.
Any more doubts or queries, members? Please unmute yourself and you can raise your query. Seems no one has any queries, sir.
Sir, good evening. I am J.V. Ravindra.
Yes, Mr. Ravindra.
Under this tax treaties, there are two components. One is financial consideration and the tax implication. Suppose if there is a dispute in the financial consideration, first the parties have to approach the ICC for arbitration.
Okay.
And in India, if suppose the one party files the case with the arbitration, so and it will take a lot of time, let us say 3 years or 4 years, and arbitration still continues, will the parties have recourse to go to the approach the court, ICC?
No, you are talking about non-tax disputes.
Yes, sir, non-tax dispute.
You are talking about non-tax disputes which are not the subject matter of this MAP process and all that.
Yeah.
And this arbitration, what we are talking is only with respect to the tax disputes.
Yeah.
So whatever process you have as per the internationally established legal procedure, you will have to follow that. That has no bearing on account of this MLI. That has nothing to do with that.
Okay.
Whatever procedure that is in vogue continues to apply.
Okay. Thank you.
I think we are through with all the questions.
Yes, sir. It seems you have cleared all the doubts in the minds of members who attended this webinar. Just a second, sir. 1 second.
Yes.
Hello. Hello. Hello.
Prasad garu, thank you very much for your wonderful and excellent deliberation. All the doubts in the minds of members got clear, so there are no much doubts expressed at the end of the session. So thank you very much for accepting our request and addressing the members of Hyderabad, sir, once again. We request you to come in person to our next forthcoming programs once the thing comes to normal.
Sure.
We'd like to invite you again for a session with members. Now I request our Secretary C.F. Prashant Kumar to propose vote of thanks.
I think Prashant has to unmute himself.
Prashant, unmute.
Yes, sir. Yes, sir. Just a minute. Respected Chairman C.S. Multilateral Learned Speaker, CAPVSS Prasad Garu and other dignitaries. Good evening to all. I am privileged to propose vote of thanks to the technical session on my own behalf and behalf of the members of the Visakhapatnam branch. Sir, I convey my heartfelt gratitude for accepting our invitation to being with us to share your experience and knowledge on the multilateral instrument and new dimensions of tax treaty laws. Thank you very much, sir. Sir, your experience deliberations on the areas like structure of MLI, action 15 plans, treaty abuse, legal framework of MLI, aids to interpretation of MLI are extremely well and exhaustively covered, sir. Sir, your special focus on case studies are helped our members in understanding the topic in clear and crystal manner. Thank you for your wonderful deliberation, sir. Thank you very much. And regarding to the upcoming programs, members on 23rd June, we have a session on NRI transactions and FEMA latest changes and challenges by CAPVRR Prasad from Hyderabad. And also on 25th Friday, we have a workshop 25th, 26th, and 27th. As our chairmen have previously announced, we have a 3 days workshop on GST. I request all the members participate and get benefited from the GST workshop and also from the 23rd session. Thank you very much. And I also extend my thanks to all the webinars who joined and got benefited with this session. Thank you one and all, and thank you for giving this opportunity, Chairman sir. Thank you very much.
And it's my pleasure, Mr. Murali Krishna and Mr. Prashant and all other bearers and past chairperson Bharti Devi ji, everyone. And my good friend Mr. Kam Shastri, who has participated, and he has logged out of CTC, where the residential, the online course, and came to this session. And it's my pleasure to meet all my friends virtually. And thank you very much. Thank you very much.
Thank you, sir. Thank you very much.
Thank you. Thank you. I think we can leave the session now.
Cut it.